Lesson: Place and manner of performance. Effective contract performance is a cornerstone of contract law, ensuring that the agreements made between parties are executed as intended. The place and manner of performance are critical aspects that dictate how contractual obligations are fulfilled. Mastering these elements is essential for professionals striving to become certified contract law specialists. This lesson aims to provide actionable insights, practical tools, and frameworks to enhance proficiency in managing the performance of contracts with a focus on place and manner. The place of performance refers to the location where contractual obligations are to be carried out. It is a fundamental aspect that can influence logistical considerations, cost implications, and even legal jurisdiction. For instance, in international contracts, the place of performance can determine which country's laws apply, impacting the rights and responsibilities of the parties involved. A practical tool for addressing the place of performance is the use of clear and precise contract clauses. These clauses should explicitly state the location where the performance will occur, reducing ambiguity and potential disputes. For example, in a supply contract, specifying the delivery address and terms can prevent misunderstandings about where goods should be sent. Manner of performance, on the other hand, refers to the method or approach taken to fulfill contractual obligations. This can include the quality of goods or services provided, the timing of delivery, and adherence to specific standards or protocols. A well-drafted contract should outline the expectations regarding the manner of performance to ensure compliance and satisfaction of all parties. Utilizing performance standards and benchmarks is an effective framework for managing the manner of performance. These benchmarks provide measurable criteria that parties can use to evaluate whether the performance meets the agreed-upon standards. For instance, a construction contract may specify that materials must adhere to certain safety and quality standards, ensuring that the finished project meets regulatory requirements and client expectations. In practice, managing the place and manner of performance often involves navigating real-world challenges such as unforeseen events, changes in circumstances, and disputes. One common challenge is the occurrence of force majeure events, which can impede performance and lead to contractual breaches. A force majeure clause can serve as a practical tool to address such scenarios by outlining the conditions under which performance may be excused or delayed due to events beyond the party's control. This clause should be carefully crafted to include relevant events such as natural disasters, pandemics, or governmental actions, providing a clear framework for managing performance disruptions. Another challenge is the need for contract modifications when circumstances change. Whether due to economic shifts, technological advancements, or other factors, contracts may need to be adjusted to remain viable. The use of a contract amendment process is a practical tool that allows parties to mutually agree on changes to the contract terms. This process should include a formal procedure for proposing amendments, obtaining consent from all parties, and documenting the changes. By establishing a clear amendment process, parties can adapt to changing circumstances while maintaining the integrity of the contract. Case studies illustrate the importance of effectively managing the place and manner of performance. In the landmark case of Hadley v. Baxendale, the failure to specify the manner of performance led to a significant legal dispute. The case involved a delay in the delivery of a mill shaft, resulting in lost profits for the mill owner. The court ruled that damages could only be recovered if the consequences of non-performance were foreseeable at the time of contract formation. This case underscores the importance of clearly defining performance expectations and potential consequences in the contract. Statistics further highlight the impact of performance management on contract success. According to a study by the International Association for Contract and Commercial Management, organizations that effectively manage contract performance experience a 9% improvement in contract outcomes, including cost savings and reduced disputes. This demonstrates the tangible benefits of implementing practical tools and frameworks for managing the place and manner of performance. Professionals can enhance their proficiency in this area by adopting a systematic approach to contract performance management. This includes conducting a thorough risk assessment to identify potential challenges related to the place and manner of performance. By analyzing factors such as geographical risks, regulatory requirements, and logistical considerations, parties can proactively address potential issues. Additionally, engaging in regular performance reviews can help ensure that the contract is being executed as intended. These reviews should involve all relevant stakeholders and focus on evaluating performance against the agreed-upon standards and benchmarks. Developing strong communication skills is also essential for managing performance effectively. Clear and open communication between parties can help prevent misunderstandings and facilitate timely resolution of any issues that arise. Establishing regular communication protocols, such as scheduled meetings or progress reports, can keep all parties informed and aligned throughout the contract lifecycle. In conclusion, mastering the place and manner of performance is crucial for contract law specialists seeking to ensure the successful execution of contractual obligations. By utilizing practical tools such as clear contract clauses, performance standards, force majeure clauses, and amendment processes, professionals can address real-world challenges and enhance contract outcomes. The insights and frameworks provided in this lesson offer a comprehensive approach to managing contract performance, empowering professionals to navigate the complexities of contract law with confidence and expertise.